You write me, Booker at bookerlawfirm.com. Your question ends up on the show. Bring you to the court of my public opinion. We're not going to look at this as legal advice because I don't represent you and I may not have all of the facts that I need. However, I'm going to do the best job that I can with what I have. Without further ado, let's get it crack-a-lacking. Order in the court. You already know what time it is. It's your favorite attorney, Attorney Allie Booker. It's order in the court. You email me. You send me your question. You make sure that you put the show, Order in the Court, in the subject title. And then I bring it on this show and I discuss it with you all. Don't look at this as legal advice because I don't technically represent you. However, based on what you give me, I will give you my best professional opinion. Without further ado, let's get it crack-a-lacking. Order in the court. How do I know if a negligent business owner carries liability insurance? 8 days ago, I suffered a fall out of business due to a hazardous condition on their property. There was a puddle of oil that matched the ground and wasn't easily visible. There were video cameras that were recording this incident. I immediately went to the nearest emergency room and ended up hospitalized with multiple injuries. I'm in need of surgery, and I also suffered a traumatic brain injury, concussion, broken ankle, torn shoulder ligament, torn knee alignment as well. Torn knee ligament as well. I'm afraid they might not carry any liability insurance and I may not recoup all the monetary damages I'm suffering. Will an attorney take my case before they know the business carries insurance coverage? It's better to file myself in court and save the 33, or is it better to file in court and save the 33% fee? What do I do? Order in the court. One thing you never are going to do is take on an insurance company by yourself, or to take on litigation that has to deal with a personal injury alone. I always tell people that gone are the days that personal injury has been very lucrative and easy to get. You do not get money easily anymore. These insurance companies have suffered, especially since Corona. Before Corona, and probably when Bill Clinton was in office and George Bush, it was very easy to hit on personal injury claims. You throw your records at an insurance company, you put the claim number on them, and they start to offer you money. You go back and forth and you negotiate, and you come out with an amount. It's not that easy anymore. Mostly all claims are denied outright. And the ones that are not denied outright are given low-balled offers, okay? So what the insurance industry is trying to do is prevent people from just filing these claims willy-nilly, because they have to pay the money for these claims. So the first thing I'm going to tell you is I would never try to file a case on my own, and especially not a personal injury case. It's too intricate. There are too many rules that you must follow by, and I don't believe there's any way possible without proper, licensing from the state bar in your state that you can even handle a case like that. It's a medical case. Records have to be certified. They have to get into evidence. It's not easy. And you're dealing with experts because you're dealing with doctors. You have to get them designated. And there are many other things that you have to do in order to run a personal injury case. So to answer your last question first, don't try to do it by yourself. Number 2, most places have insurance. And this comes from my friend who worked for an insurance defense firm for some time. She started out on plaintiff's litigation just like myself. Then she started working for an insurance company. And now she's back in plaintiff's litigation like myself. She argues that many businesses carry insurance on their properties. The reason that many businesses still carry insurance on their properties is because they don't own the property outright or the building outright. And many of the leases require that they carry insurance so that the person who does own the property is not sued in their stead or in their place. So more than likely, this facility is going to carry liability insurance. However, there are many ways for an attorney to figure out whether or not a specific individual or company carries liability insurance on a specific piece of property. It isn't cheap, but there are ways for them to find this out. More than likely, sir, there is some sort of coverage on this property. I can't tell you 100%, but more than likely there is some sort of insurance on this property. The issue is whether or not they're going to be liable for your slip and fall. And I tell people this a lot because I handle slip and falls. Slip and falls have been some of my most lucrative cases. I have hit the most on slip and falls. And it's very easy to get a slip and fall case up to the 6-figure mark. Very easy. The issue is making liability stick. It's easy to run a case up. It's hard to make the liability stick. And when you're dealing with a property, you have to make sure that this was a danger that they knew or should have known about, that they had a reasonable time in which to discover that danger, and that they did not warn the customer that the danger was there. Case in point, when you're trying to file a case against a supermarket and the argument is somebody dropped a piece of apple on the floor and you slipped on it, more than likely you're not going to win that case. Why? Why is because they have a huge number of people walking in and through the supermarket. Number two, you can't prove that the owner put that, or that the store personnel put that apple on the floor. So if the store personnel didn't do it, the issue is going to be who did it. And more than likely, it's going to be a customer. If a customer did it, when is the last time that they came by and checked? That's why many of the businesses that you frequent will have a check sheet where they have to check things every so often and check spaces every so often for spills, drips, and cautionary items such as spills and the like. Okay? If you can prove that they knew or had reason to know that that oil was going to be on the ground and they did not notify or put a caution sign down, then you've got a case. That is why anytime somebody cleans a restroom, they put the caution sign down. Why? Because they created that dangerous condition. So by nature of the fact that they swept and mopped that floor, they knew or had reason to know that the floor was wet. Then it picks up that they have to warn you. If somebody did not put the substance on the floor, trying to prove that they knew or had reason to know that it was there is difficult to do. That's why much of the times I don't sue in supermarkets, although I have, and I have been successful. It's better to have a lawsuit against a place that has let's say there is a cooler in the middle of the floor. That's where their ice is, and the cooler is dripping water. That cooler has been replaced and it has been serviced multiple times and it's still broken. Or it's been serviced multiple times and it's broken again. Those are good cases. Why? Because clearly they knew, the store owner, store personnel knew or had reason to know that there was an issue with that particular freezer. Okay? It's dripping water onto the floor, and they created that dangerous condition because they knew or had reason to know that that cooler was broken and they haven't fixed it. Another good case in point. Example, rugs. Okay? If it is a rug in the middle of the floor and that rug seems to get caught up and somebody comes into that store and slips on that rug, more than likely, yes, you're going to be able to recoup your medical expenses. Why? Because they put the doggone rug in the floor. They know or have reason to know that hundreds of people are going to come in and out this doggone store. I sued they were very upset with me because the argument was, I know this lady, she's a drug abusing individual. She comes in here all the time to play our game machines, and she did not trip and fall on that mat and hurt herself. She always walks over that mat, and she should have known that mat was there. My argument to them was, sir, you don't put a mat like that, of that caliber, in front of the store. That mat was old. It was already ruffled up on the edges, and you all are the ones who drag that mat in front of that door every other day and every day. My client fell on that mat, and so it's your fault. Because you shouldn't have had the mat right there for her to fall on while it was rolled up. You knew or had reasons to know that there are issues with that mat. She knew because she comes in there and plays the game machines all the time. And there have been several people that have fallen by that door that she has seen fall on that mat. And on this particular day, she was on her way in to grab a drink, and she wasn't paying attention and fell on the mat. The mat was rolled up though. If you know that that mat creates a dangerous condition, you aren't to have it right there by the door. Or you have to have the proper mat by the door. I was able to sue them in that particular case. There are certain mats that you have to have in certain places that are industry standard. And then there are standards where they have procedures not to put mats in certain places because people kick them and they tend to get rolled up and messed up. If you pay attention to Walmart, they don't have mats at the front anymore. What they do is once there is some sort of liquid down, they put a sign there. But you don't see mats coming in and out of the restrooms anymore at Walmart because it created a dangerous condition. Why? Because you put the mat there, somebody's going to kick the mat's going to be rolled up, and the next person's going to trip over the mat, move the mat. Okay? So it's not easy to get them to claim liability or to make them liable. But it is easy once you do so to hit big on a slip and fall case. I need a little bit more information, but I'm going to say this. If this is a puddle of oil and you're at an automotive shop, they knew or had reason to know that there would be oil there. So they shouldn't have been able to allow you to walk in an area where the cars were. If they allowed you to walk in an area where the cars were and you slipped on some oil, sue the hell out of them. Sue them. Because that's why people are not allowed to go in the back or go in certain areas where the cars are. Because the cars drip oil. It creates a dangerous condition. And that's a problem. I got to know where you were, though. The business has to know or have reason to know that that oil was going to be on the ground. Also, you're saying that the oil was not easily visible. That's not good, and that doesn't help your case. Because they have to know or have reason to know of the dangerous condition. And if the dangerous condition is not something that is easily discovered, you can't say they should have known about it. So you have to be careful also when you're telling your story. Not trying to discourage you because you could probably change your life with this case. But just give me a little bit more information so that I can help you. But guys, water that has fallen on the ground at the supermarket, they're not going to pay you for. Water that drips from their ice machine that's been broken before, oh, they owe you there. Okay? Oil in an area that you're not supposed to walk in an auto shop, you won't get money there. Oil somewhere where they allow people to walk, you're going to get paid. Next case.